Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, conflicts and confidentiality in California practice. Let's begin. Professional responsibility essays require two tracks at once: the California Rules of Professional Conduct and the ABA Model Rules. California has its own wording and some distinctive rules, but the exam often expects comparison. The safest approach is to state the California rule first, then note the ABA rule if different. Conflicts and confidentiality are especially high yield because they arise in litigation, transactions, business deals with clients, former client matters, and joint representations. Think like a lawyer protecting client autonomy, loyalty, and secrets. Ask, who is the client? What duties are owed now? Is there a current client conflict, former client conflict, personal interest conflict, business transaction with a client, or third-party payer problem? Can the conflict be cured by informed written consent, or is it non-consentable? Separately, ask whether information is protected as a confidence or secret and whether disclosure is permitted or required. Current client conflicts. Under California Rule 1.7, a lawyer must not, without informed written consent, represent a client if the representation is directly adverse to another client, or if there is a significant risk the lawyer's representation will be materially limited by responsibilities to another client, a former client, a third person, or the lawyer's own interests. ABA comparison. ABA Model Rule 1.7 similarly prohibits direct adversity and material limitation conflicts unless the lawyer reasonably believes competent and diligent representation is possible. The representation is not prohibited by law. The clients are not asserting claims against each other in the same proceeding, and each gives informed consent confirmed in writing. Former client conflicts. A lawyer who formerly represented a client must not represent another person in the same or a substantially related matter if that person's interests are materially adverse to the former client, unless the former client gives informed written consent. See California Rule 1.9. The substantial relationship test protects confidential information. Confidentiality. California Business and Professions Code Section 6068(e) requires an attorney to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of the client. California Rule 1.6 ties confidentiality to that statutory duty. ABA Model Rule 1.6 bars revealing information relating to representation unless the client gives informed consent, disclosure is impliedly authorized, or an exception applies. California Death or Substantial Bodily Harm Exception. California permits, but does not require, disclosure of confidential information to prevent a criminal act the lawyer reasonably believes is likely to result in death or substantial bodily harm, after efforts where reasonable to persuade the client not to commit the act and to inform the client of the lawyer's ability or decision to reveal. See Rule 1.6. Conflict analysis. Identify each client and former client. Identify the matter and the lawyer's role. Determine whether interests are directly adverse or materially limited. Determine whether the conflict is current client, former client, personal interest, or third-party conflict. Decide whether the conflict is consentable. If consentable, require informed written consent under California rules. Discuss withdrawal, disqualification, discipline, or fee consequences if consent is absent. Confidentiality analysis. Identify the information. Determine whether it was learned in the representation or relates to representation. Determine whether the client consented or disclosure is impliedly authorized. Analyze exceptions under California and ABA rules. State whether disclosure is permitted, required, or prohibited. California frequently requires informed written consent, not merely oral consent. Informed consent means the lawyer communicated the relevant circumstances and actual and reasonably foreseeable adverse consequences. Written consent means the client's written agreement or a writing promptly transmitted confirming oral consent, where the rule allows. For conflicts, the lawyer must explain how loyalty and confidentiality may be affected. In joint representation, the lawyer should explain that information material to the representation may need to be shared among jointly represented clients, that the lawyer may have to withdraw if adversity develops, and that privilege may not protect communications between joint clients in later disputes between them. Some conflicts are non-consentable. A lawyer cannot represent opposing parties in the same litigation. A lawyer cannot proceed if the lawyer cannot competently and diligently represent each affected client. A conflict prohibited by law cannot be waived. Note: on the California bar, failure to obtain written consent is a separate issue, even if the client likely would have agreed. Direct adversity. Lawyer represents client A in a contract negotiation while suing client A on behalf of client B in an unrelated matter. Even if unrelated, direct adversity to a current client creates a conflict requiring informed written consent, and it may be non-consentable if loyalty is seriously impaired. Former client. Lawyer represented company in negotiating a distribution agreement. Later, lawyer represents distributor against company in litigation interpreting that agreement. The matters are substantially related and interests are materially adverse. Former client's informed written consent is required. Personal interest conflict. Lawyer enters a business deal with a client, takes stock instead of fees, or has a romantic or family interest affecting advice. California Rule 1.8 imposes specific safeguards for business transactions with clients: fair and reasonable terms, written disclosure, advice to seek independent counsel, opportunity to do so, and informed written consent. Third-party payer. A parent, insurer, employer, or friend pays fees. The lawyer must ensure the arrangement does not interfere with independent judgment or confidentiality and must obtain required consent. The payer does not become the client merely by paying. Confidentiality is broader than attorney-client privilege. Privilege is an evidentiary doctrine allowing refusal to disclose confidential communications for legal advice. Confidentiality is an ethical duty covering secrets and information relating to representation, whatever the source, even if the information is publicly available in some contexts or not privileged. California's confidentiality duty is especially strict. The main permissive exception concerns preventing a criminal act likely to result in death or substantial bodily harm. The lawyer should, if reasonable, try to dissuade the client and warn of possible disclosure. Disclosure must be no more than necessary. ABA exceptions are broader. ABA Model Rule 1.6 permits disclosure in several situations, including preventing reasonably certain death or substantial bodily harm, preventing certain client crimes or frauds using the lawyer's services, preventing or mitigating substantial financial injury from such conduct, securing legal advice about compliance, establishing claims or defenses in disputes with the client, complying with law or court order, detecting conflicts, and other listed exceptions. Saying consent is enough, without saying informed written consent under California rules. Forgetting former clients. Loyalty changes, but confidentiality survives. Disclosing financial fraud under California simply because ABA would permit it. Compare the rules. Confusing privilege with confidentiality. Privilege is narrower. A classic essay. Lawyer represents both spouses in selling a business. One spouse privately tells lawyer about hidden liabilities and asks lawyer not to tell the other. Analyze joint representation, confidentiality, and conflict. The lawyer likely had a material limitation conflict from the start requiring informed written consent. The private information is confidential, but in a joint representation the lawyer may have disclosed limits on keeping secrets between joint clients. If continuing would require misleading one client or withholding material information, withdrawal may be required. Another pattern. Lawyer formerly represented a company in employment policies, then wants to represent an employee suing the company for discrimination involving those policies. Discuss substantial relationship, material adversity, former client consent, and imputation. Then separately analyze whether confidential information can be used. A strong answer states California first, compares ABA where different, and gives a practical remedy: obtain consent, decline, withdraw, or protect confidences. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.